Hi, I'm Professor Rodgir Cohen. I'm your professor here. I want to talk today about civil asset forfeiture. Civil asset forfeiture is a growing problem in America and something that really should be addressed. Private property rights in the United States are utmost importance. Most Americans would be outraged if law enforcement officers could seize their well-deserved property without charging them with a crime. Imagine if people who had, your furniture in their front yard, or you had your new toy out front, and police just came by and took it. Throughout the United States, police and prosecutors can confiscate cash, though, a home or any private property suspected of being associated with a crime. Moreover, public authorities do not need to charge or associate private property owners with a crime as well. Civil asset forfeiture is the discussion today, which we want to illuminate. Asset forfeiture victims are often too disadvantaged to seek their rights through legal means. Sometimes the poorest of the poor are the ones targeted the most, and they don't have the legal means nor the capacity to know where to turn to in order to seek and redress their problems that have happened to them. Even if you object to civil asset forfeiture by exercising your legal rights, the average fee you will pay to a lawyer for a lawsuit is over $3,000, and in some areas it skyrockets to $8,000 just to get your property back. So if the police take something small from you, like your iPhone, because it's suspected to be used in a drug deal, then you lose the iPhone because it's cheaper than getting an attorney than it is to get your iPhone back. Therefore, consent to unlawful treatment is more economically meaningful than hiring a lawyer to seek your rights. This becomes the problem with civil asset forfeiture. Are people giving up their consent to unlawful treatment? And is this more economically meaningful to them than hiring a lawyer? Sadly, the answer is not good. Statistics show that the Policing for Profit report by the IJ, $68.8 billion of property has been confiscated since 2000. While $23 billion of these proceeds were collected under state laws, $46 billion were collected under federal laws. The importance of income from forfeiture for law enforcement agencies becomes even more apparent when considering that 70% of the property forfeited in 2018 was cash or convertible goods. Within the state of California, asset forfeiture at the state level, California forfeited $440 million on property between 2008 and 2018, according to available data. Between 2000 and 2009, California law enforcement agencies received $1.3 billion in proceeds from forfeited properties from federal equitable sharing. Since 2016, in California, agencies can only receive proceeds of forfeited property worth over $40,000 from federal equitable sharing. For this reason, post 2016, federal level forfeitures partially decreased. Despite some improvements to its forfeiture law in 2016, California offers little detail on forfeited properties. It does not disclose the individual value of the forfeited properties or the type of property. California does not disclose the type of forfeitures that it does. Civil asset forfeiture in California has more problems. Before the war on drugs began, civil forfeiture was a rarely used legal tool, and its scope was extremely limited. The Comprehensive Drug Abuse Prevention and Control Act of 1970 started to expand the fight against drugs. Civil asset forfeiture in California continues to be a problem because before the war on drugs began, civil forfeiture was rarely legally used, and its scope was extremely limited. This Comprehensive Drug Abuse and Control Act of 1970 expanded the fight against drugs and used assets and currencies traceable to drug transactions, and those became subject to civil forfeiture in 1978. By 1984, real property, and in 1986, cars, boats, businesses, houses, and land were included in a list of things that can be seized under civil forfeiture laws. The problem continues in California. Moreover, the Department of Justice Asset Forfeiture Fund, established in 1984, prevents the transfer of forfeiture proceeds to the Treasury's general fund. State law enforcement officers retain a sizable portion of the forfeit proceeds after they carry out the property seizures, called adoptive forfeiture, within the framework of federal laws. These forfeitures, not allowed under state laws, have proceeded under federal laws, and the state government is prevented from auditing these forfeitures. It just keeps getting worse, doesn't it? While the proceeds of the Department of Justice Asset Forfeiture Fund were $93.7 million in 1986, these figures now reach $8.2 billion in 2017. So you have to be asking these questions: whose properties are being forfeited in California? According to the Civil Liberties Union, ACLU, of California's civil asset forfeiture policy brief, 85% of law enforcement officers who receive civil forfeiture proceeds in California serve people of color. There's a discriminatory factor here. It's obvious if people were to be looking at this. Half of California's Drug Enforcement Administration, DEA seizures, involve Latino names. Personal stories can be highlighted here in California. These stories are examples of how the practice of civil asset forfeiture can turn into an arbitrary discretion that cannot be easily controlled. I've seen stories of janitorial business owners. In 2014, a businesswoman driving her car on the I-5 out of San Diego freeway was pulled over by the LA County sheriff's deputies. The police, who told the driver they stopped her because she was driving suspiciously, got the driver out of the car and into the back of a police car. And then the officers found $18,000 when they searched her car. All of the woman showed the police documents proving that the money was withdrawn from the company account and would be distributed to the employees as wages. The police did not find the woman's answer convincing. After the officers seized the woman's money and her car, they abandoned her at a closed Santa Clarita police station, and the woman got her money back due to a lawsuit. However, it took 2 years that she was without her money and those lost wages for people. This is not acceptable. A taco truck owner I saw near Lancaster, a taco truck owner was pulled over by the police and asked if he was carrying cash with him. There were no drugs in the car and his job was legal. The taco truck owner did not hide the $10,000 he was carrying from the police. However, the police seized the taco truck owner and the owner's money, while the taco truck owner was not charged or arrested with any crime. He filed a lawsuit against forfeiture and won, but had to wait. During these times, people are losing their capital and their money just so that the police could seize their assets without due process. I read a story about a computer repair shop owner. In June 2017, the police raided the computer shop that Frank Ranelli had run for 20 years and seized 130 computers. The police claimed that Ranelli was selling stolen computers, citing evidence of an informer. However, when Ranelli showed that he had the computers by taking the official procedures, it dropped all charges against him. He could not retrieve his confiscated computers after years of trying. Talk about losing all of your assets just because the government was wrong. Civil rights. It is a problem in California with civil asset forfeiture. Basic individual rights, such as the right to property, are innate rights that one can claim against the government through judicial processes. These unlimited powers that the civil asset forfeiture gives law enforcement to citizens cannot be kept under control or used for good intentions. I mean, you can't just say we have the power. Once you give it away to the government, it becomes something that's uncontrolled. The only type of forfeiture compatible with the rule of law is criminal forfeiture. I'd like to thank you for tuning in to our lecture today. The purpose of this lecture is for an academic environment, but as well, we should all be going forward to spread the word that people's liberties and freedoms should be protected in California from civil asset forfeiture.